So greetings, everyone. My name is Angela Acheng. I am a lawyer, I'm a trainee advocate, and I'm the founder of Sharia Clinic. So Sharia Clinic is a virtual Kenyan legal-based, Sharia Clinic is a legal aid firm that is virtual, and we have two primary objectives. Number one, we seek to provide legal aid services to Kenyans who can't afford it. That is known as pro bono services. And number two, we seek to enhance the participation of young lawyers through equipping them with advocacy or practical skills. So our target audience is not just the lawyers or students, but generally the general public, because law permeates all sectors or all spheres of life. So without further ado, I would like to introduce the presenter of today. And he is none other than, as you have seen in the poster, Wakili Hassan Mahmoud Ibrahim. So I need to introduce him very well because he's a man of many titles. So first and foremost, he's a legal officer at Pathologist Lancet Kenya. He is also the former chairman of the Nubian University Student Organization, known as NUSO. He is a member of Haiba Foundation, which gives mentorship programs and education in the community. He's a seasoned mooter. That means he has participated in mooting activities in his undergraduate. He's a graduate of the JKUAT School of Law, Karen campus. He was the best public speaker in 2009 and 2012 in the Great Debaters Contest. I'm sure if you watched Great Debaters Contest, you know what I'm talking about. He was also the East African, he also received an award known as the East African Nubians Award in the year 2018. And during his free time, he loves volunteering, and he does particularly he volunteers with regards to education and youth empowerment in the community. So that is just part of what he does. Yeah, he has a very good CV, so I can't be able to finish it today, but yeah, so I'm honored and glad to have our counsel here. And the topic of today is, do judges make or declare the law? It's a jurisprudential matter, and we would love to hear from him. So Counsel Hassan Mahmoud Ibrahim, the floor is yours. You will take 20 to 30 minutes. So I'll stop you at around 8:40 or 8:35 or 8:40. Thereafter, we'll have questions and answers session, and then we'll wrap it up by 9 p.m. So Counsel, it is your time. Thank you.
Thank you, Counsel Angela. I'm grateful to be on this platform today. My name is Hassan Mahmoud, as you have introduced, and I'm happy to be on this platform to share with my colleagues, both those who are lawyers and those who belong to different professions, and even those who don't belong to any profession. So for me, it's an honor. It's an honor to be presenting on this topic, and my topic for today is do judges make or declare the law? It's something that is actually out there, and in the recent judgment that we've seen at the Court of Appeal level, even from High Court level, a lot has been debated about whether it is the role of judges to make the law or to declare the law. I'll begin my presentation by saying that under the doctrinal structures of law, the function of Parliament is to make laws, while the function of the executive is actually to implement the laws, and that of the judiciary is to make sure that, is to adjudicate or to provide solution to cases that have been brought before the court of law. And therefore, from these three functions, you then get to see the separation of power, where each organ of government has its own responsibility, has its own role to play. With that in mind, one would question, therefore, whether it is the role of the judiciary in interpreting the law or in analyzing a case before the court, whether it is in their mandate to declare or to make new laws. I'll begin by saying that this is an area that has an area of law that has brought a lot of debate. For a long time, it has been argued, for example, that judges filled in the gaps left by the rules by using their discretion. By their discretion, it means they have the liberty to analyze, to interpret the law, and come up with their own finding. A good example, we have positivistic jurisprudence, for example, from Austin. And we know Austin and Hart, most of them, those who've done law, they were actually, their agitation was on the basis of structures in law that enables judges to play their role. It therefore means the role of a judge, when a matter is brought before him or her, is to ensure that they apply the law to the facts and to come with a just verdict. There are, however, other proponents who say that when a case is brought before a court of law, for example, interpretation of a statute, it becomes the role of a judge to ensure in interpreting that particular law, they conform to the societal needs. Societal needs mean the society is changing. Society is dynamic. Things are changing on a day-to-day basis. That's why in other jurisdictions, for example, you find that abortion is prohibited, while in other jurisdictions, abortion is actually allowed. So the basis of this presentation would therefore to answer two questions. Is it possible to reach a consensus on judges' role through a philosophical way? And two, assuming that judges don't make law, then is it always possible to declare the law? Those are the questions that my presentation intends to answer. And so the first point that I would want to go to is to try to analyze and to look at the jurisprudential principles regarding interpretation regarding interpretation of judgments and coming up with decision by courts of law. So then, how do judges make laws? Is a key question that needs to be answered. And therefore, it is argued that it is wrong for judges to make the law because people delegated their sovereign power to Parliament. And therefore, whatever Parliament is doing, it is doing on behalf of the people. So that power cannot be sent back to other people because it will not be okay, because it is not the function of Parliament, the function of judges to do that. It is for the Parliament to make the law. Parliament is elected to do this, but judges are not. This means that lawmaking by judges is undemocratic. That is one assumption that has been made by those who are against this principle. But in reality, judges have to make law in some situations. The first one is where, for example, a case involves a legal point that has never been decided before. As there is no law, therefore, the judges in the case have to make a decision. And some of those decisions come out to be law. After all, the parties in the case would not want the judge to refuse to deal with the case. They want quick and expeditious dispensation of justice. The second reasoning is more controversial, and this is where judges overrule old cases. And in doing so, they create new laws. Okay? It is important for the law, because it is important for the law to be updated in this way. Because a law for the 21st century needs to be based on today's society and values. You cannot use a law created in the 18th century to solve a problem in the 21st century. Of course, you can use it for persuasive reasons, but that particular law has to conform with the societal need. Therefore, law decided in 100 years or more ago may no longer be suitable. Ideally, Parliament is sometimes slow to do that. Therefore,